Basic Legal Research, Statutes. This learning video will have 3 specific goals. First, we'll answer the question, what are statutes? Second, you'll learn where statutes are found and how they're organized. And third, you'll learn the differences between official and unofficial codes and annotated versus unannotated codes. By now, you've probably learned the difference between primary and secondary authority. By way of review, primary authority is the law, whereas secondary authority helps to analyze, interpret, and apply the law. The main sources of primary authority are constitutions, statutes, regulations, and cases. A statute is a positive statement of legal rules enacted by a legislature. Statutes are created by the legislative branch of government at both the federal and state levels. Statutes codify, clarify, or supplement pre-existing common law, overturn common law, and create new areas of law not covered by the common law. Statutes are compiled into what are called codes, which gather together the laws on a particular subject or topic, incorporating statutes with subsequent amendments and removing any repealed, superseded, or expired laws. Codes typically contain a detailed index. The federal government has its own code, as does every state. Now, each code is arranged differently. For instance, the federal code, called the United States Code, has 51 titles. Each title is divided into chapters, and each chapter is further subdivided into sections. Some codes are arranged by subject name instead of title. As a state example, the Utah Code is divided into titles, chapters, parts, sections, and subsections. A title generally contains a single general subject, such as labor or public safety. The Utah Code currently contains 79 titles. A title is then divided into chapters along more specific subject matter. Codes are published into several formats, both in print and electronically. When the government arranges for publication of its laws, this is referred to as an official code. Official codes may or may not be published by the government itself. Sometimes, governments will contract with a commercial publisher to print their official codes. Many states no longer publish their own codes and leave this to commercial publishers, primarily LexisNexis or Thomson Reuters. The official United States Code is published by the U.S. Government Printing Office, or GPO. The Utah Code is published by both LexisNexis and West. Table 1 at the back of the Blue Book will tell you which version of the code to cite if there's more than one. Typically, one cites to the official code, if one exists. Since new laws are always being enacted and existing ones amended or repealed, codes must be updated to reflect the current state of the law. Print codes are updated by annual pocket supplements, monthly pamphlets, and, when necessary, by replacement volumes. Some codes are reissued on a regular basis. Online codes may be updated automatically, but depending on the database, you'll want to confirm this. You always want to make sure that you have the most recent edition of any code that you're working with. Published codes come in 2 formats, annotated and unannotated. An unannotated code contains only the text of the law and possibly a few historical notations. They are much shorter than annotated codes. Annotated codes are especially useful when doing research, as they contain summaries of relevant cases or citations to secondary sources discussing a statute. Note that the text of the code itself should be the same despite the source. There are currently 2 annotated versions of the U.S. Code published. The United States Code Annotated, or USCA, now published by Thomson Reuters, and the United States Code Service, or USCS, now published by LexisNexis. It's important to note that the 2 different annotated codes may contain different annotations. You may find a reference to a particular case, journal article, or treatise in the USCA, for instance, which is not listed in the USCS. Each publisher will typically reference its own publications and annotations, especially when it comes to treatises. That's why you want to check both sources in doing your research, assuming you have access to both. The state of Utah has two annotated codes, one published by Thomson Reuters and the other published by LexisNexis. Quite often, the meaning of a statute isn't clear, and courts must frequently interpret language used in the statute. This is when legislative history research is helpful. Legislative history describes the documents which contain the information considered by the legislature in enacting the legislation. Compiling a legislative history involves locating the documents generated by Congress during the legislative process. These documents help to shed light on the intent of a legislative body in passing law or determining the meaning of specific language used in the law. Legislative histories can be done for both federal and state statutes and are covered more in depth in advanced legal research courses. It's important to note that in the American legal system, there is no presumption that a statute will apply to every legal problem or that codes are comprehensive statements of the law. This means that there may not be a statute on a particular issue of law that you're researching. You need to keep in mind all of the resources at your disposal when researching a legal issue: statutes, regulations, cases, as well as secondary sources. Legislatures may state general legal rules in the form of statutes, which are then interpreted by the courts in specific cases. Administrative agencies, both federal and state, may create and publish regulations which further interpret or apply a statute.